Hey tribe, welcome back. This is RayTube practice question number 52, and we have two legal related questions, so stay tuned. Okay, so let's dive into it. The first question: a social worker receives a request for information of a client who recently passed due to natural causes. Although there's no release on file, the person requesting the information is a family member who had a healthy rapport with the deceased client and needs the information to complete important tasks. How should the social worker respond next? A. Provide the information to the family member. B. Maintain the information of the deceased client. Or C. Schedule a meeting with the family member. And you know how we do. Pause the video, reread through the question, reread through the answer choices, select your best answer, unpause the video, and then we'll dive into it. Okay. If you picked B, maintain the information of the deceased client, you are correct. Why? So A, provide the information to the family member. This is incorrect. According to the NASW Code of Ethics 1.07, Privacy and Confidentiality, Section W, social workers should protect the confidentiality of deceased clients consistent with the preceding standards. And regarding the preceding standards, there's no release on file. So that's why B, maintain the information of the deceased client. Maintaining client confidentiality even after the client's passing is a fundamental ethical principle in social work. Without proper legal authorization or release on file, it is generally not permissible to disclose confidential client information to a family member, even if they had a healthy rapport with the deceased client. And C, schedule a meeting with the family member. This is incorrect. Why? This option could still be seen as breaking client confidentiality. In order for the family member to obtain information of the deceased client, they would need to go through the proper legal channels to become the executor of a estate and be able to prove it so that they can obtain that information of the deceased family member. But for this one, it's B, maintain the information of the deceased client. Okay. How about legal practice question number 2? A social worker receives a legal request from an attorney for the records of their client. The social worker discussed the request with the client, who reports feeling anxious and does not want an attorney viewing their therapy records. How should the social worker respond next? A. Complying with the legal request due to the limitations of confidentiality. B. Assert privilege on the client's behalf. Or C. Speak with the attorney and advocate for the number of records requested to be limited. Again, pause the video, reread through the question, reread through the answer choices, select your best answer, unpause, and we'll dive into the explanation. Okay. If you picked B, assert privilege on the client's behalf, you are correct. Why? So let's break it down. First and foremost, what is a subpoena and who typically sends them? A subpoena is a written request to provide the records of your client and is actually dual meaning it means more than one thing. A subpoena could also be a request for the social worker, us, to appear in court for testimony. And subpoenas are typically sent by lawyers and attorneys. Someone from the court, such as a clerk, could send a subpoena or a legal request. And real quick, a legal request, that could be anything. So unless it specifically says that that legal request came from a judge, because we have to respect their authority, it supersedes us, like it overrides us because they're a judge, because they can send us something on a tissue paper, it's still a judge. So unless the question specifically says that the legal request came from a judge, even if it says a notice from a judge, we still have to respect it because it's a judge. So the court order judge rules will apply. We'll get into that in a second. But if it just says, if it does not say court order or that the legal whatever came from a judge, treat everything like a subpoena. So again, subpoenas are typically sent by lawyers and attorneys. Someone from the court, such as a clerk, could send a subpoena or legal request. Unless the question mentions that the legal request came from a judge, treat the legal request like a subpoena. What is a court order and who typically sends them? A court order is issued by a judge that instructs someone to do something or not to do something. If the question says a legal request came from a judge, treat the legal request like a court order because it came from a judge. Again, we have to respect their authority. And how should the social worker respond to any type of legal request? So court order, subpoena, was sent by a clerk. It was the judge sent this notice. First, seek some form of legal counsel if available. That is the correct answer. Why? Because, well, if we get a legal notice in the mail or whatever the case may be, I want to talk to my lawyer. I want to talk to the legal department. I want to talk to the legal professional that's going to guide us on how to respond, if we have to respond, or ultimately just how to navigate this situation. So the first and correct answer would be to seek some form of that legal counsel, speak with the lawyer. And it's not going to say A, lawyer, B, legal department or something like that. It's only going to be one legal entity. That's what we do first, no matter what the notice is. However, if that's not available, we go to option number 2. If seeking some form of legal counsel is not available, speak with your client about the request if available. You are allowed to speak with your client about the request, even if it's a court order. According to the NASW 1.07 Privacy and Confidentiality, Section D, if social workers plan to disclose confidential information, they should, when feasible and to the extent possible, inform clients about the disclosure and the potential consequences prior to disclosing the information. This applies whether social workers disclose confidential information on the basis of a legal requirement or client consent. So we are able to tell, unless it specifically says, and I never saw a question like that before or anything where it says the judge instructed the social worker not to inform the client. Like I haven't seen that. So yes, we are allowed to inform the client. And then we get into the particulars. So for the subpoena / legal request, if the above 2 options are not available, which the ones that we just went over of if this option is available, seek legal counsel. If that's not available, and then this option of speak with the client is not available, and we're dealing with a subpoena / legal request, if the above 2 options are not available, assert privilege by maintaining client confidentiality and not disclosing any information about the client, which includes even knowing the client. You cannot assert privilege for a court order or if it mentions that the legal request came from a judge. Asserting privilege is only for the subpoenas and those legal requests. So if those 2 options aren't available, we assert privilege. And that's why it's the correct answer for B, because when we scroll back up to the question, remember, we're dealing with an attorney. It didn't say anything about a court order or a judge. So we have the option to assert privilege, especially since in this scenario right here, we already spoke with the client and the client's like, hey, I don't want them having my records. Now, if this was a court order type of situation, so a court order / legal request sent by a judge, so the question mentions that it came from a judge, if the above 2 options are not available, which again is the same thing, number 1, seeking some form of legal counsel, and number 2, if that's option number 1 is not available, speaking with the client about it. If those 2 options are not available for court orders or a legal request sent by the judge, we advocate on behalf of the client by asking the judge to reduce the number of records to turn over or to keep them under seal to protect the client if it has not already been done so within a question itself. We have to advocate. A social worker receives a court order from a judge for the records of their client. What should the social worker do first? Or what should the social worker do next? Well, we need to advocate. So we will want to pick that answer. But let's say if the social worker already advocated within the question itself, a social worker receives a court order from a judge for the records of their client. The social worker advocates for the judge to reduce the number of records being requested. The judge denies that request, or they agree to that request. Then we pick the answer that corresponds with that. So if the social worker already advocated within the question itself, do what the judge agreed upon. If the judge agreed to reduce the number of records to turn over or to keep them under seal to protect the client, then the correct answer would be to turn over the number of records the judge agreed upon. And do not turn over additional records because that would defeat the purpose. Hey, judge, can we limit the number of records we got to send over to you to protect the client? And it just says, sure, that makes sense. And then we say, actually, we're still going to send more. And it's like, oh, we're doing too much, right? And if the judge declined our request to reduce the number of records to turn over or to keep them under seal, then the correct answer would be to turn over what was requested by the judge. So we're not going to keep advocating. It only takes one conversation. We advocate to the judge on our client's behalf. And unfortunately, if the judge said, nope, I want those records, then we have to adhere to it. We don't keep advocating to the judge. If the judge declined your request to reduce the number of records to turn over or to keep them under seal, then the correct answer would be to turn over what was requested by the judge. And also, do not, N-O-T, not, edit/alter the notes prior in order to protect the client. The social worker could face legal consequences if they do. So we don't want to do that. And the exception, the social worker is able to edit documentation errors such as the wrong date/time, billing codes, etc. The social worker would need to document exactly what was edited/altered when doing so. So let's say if we got to turn over records and we're like, oh snap, we put the wrong date on the notes. We realized that, oh, it's 2024 and we put 2025. Whoops. Or we put the code for a family session, and silly me, it's an individual session. We can correct those type of errors, and of course document exactly what was edited from the notes before sending it in, but not doctoring up the notes, going back 2-3 months ago, changing out, taking out sentences and everything. So we always want to be mindful when we're documenting, and be mindful not to edit, doctor up the body of the notes regarding that type of stuff to protect the client, because we could face legal consequences. Okay, tribe, that's it for today's video. That was RayTube practice question number 52, breaking down 2 legal related questions, one more so with confidentiality and the other one more so dealing with how to respond with that legal notice, also essentially dealing with confidentiality. As always, don't forget to like, comment, and subscribe, and tell a social worker because we don't want to be licensed by ourselves. And you know how I say, you got this. 2 practice questions a day, and we did 2 practice questions a day. So essentially, when you watch this video, and at least 1 practice exam a month helps keep the exam anxiety at bay, and it just puts us in a really good exam state of mind so that we can pass our exam. So 2 a day, 1 practice exam a month. All right, tribe, I'll see you next video.